Hey out there, legal warriors. In this video, I'm going to cover 3 methods that can help you get your felony charge reduced to a misdemeanor. It's not easy, but it's not impossible. Stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Lynnwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get to see it. More people get the help they need. Now we're just going to jump right into it. Let's start with the basics. What is a felony charge, and why do we care about a felony getting reduced to a misdemeanor? Well, in Washington State, a felony charge is defined as any crime where the maximum penalty is 1 year or greater. And actually, there's only 3 levels of felonies in Washington State. Class C, which has a 5-year maximum. Class B, which is a 10-year maximum. And Class A is going to be 20 years or more. It could be more depending on the nature of the charge. But there's collateral consequences if we're convicted of a felony charge. You lose your right to vote. There's DNA that has to be taken of you, and you also lose your right to possess firearms, and of course you're probably going to prison. So we don't want to be convicted of a felony. If a felony charge gets reduced to a misdemeanor, there's no loss of right to vote. Most likely, in many cases, there's not going to be jail time recommended because we're reducing it from a felony to a misdemeanor to avoid that jail time. Typically the prosecutor is. And also, there's a very good chance you're not losing the firearm rights in that situation. So when I think about the primary ways of getting a felony reduced, I think of sort of a mnemonic type idea. I think there's force, there's facts, FACTS, and follow-up. Force, facts, and follow-up. Now, I'm going to go over those one by one, but I'm probably not going to go in that order, but it sounded the best to put it that way. So let's start with facts. The most common way we can think about getting a felony down to a misdemeanor is to challenge the facts that are alleged in the police report, right? The police report says they allege that one person choked their partner, and because it's a strangulation case, that makes it a felony case if it's in Washington State. Strangling your partner, strangling another person is a domestic violence. If it's your partner, assault in the 2nd degree, that's a felony. But strangulation is sort of tough to define. And now this is not a video about that charge, but it's an example. If we can challenge those facts and make it point to the prosecutor, hey, you're missing some facts here, right? There's no, little dots in the eyes. I forget what they call that. Begins with a P. And there's no marks on the neck, and the police got it wrong. Well, maybe the prosecutor believes that their fact pattern isn't as strong as they think it is, and therefore they might be willing to reduce the case. Additionally, you might go out and develop your own fact pattern, right? Your own facts, where you can have an investigator go out and interview people and get a different point of view, or an investigator can talk to the police officers, right? And maybe they say some different things than what they say in the report, or the alleged victim. There's also just all types of ways to factually challenge things, right? If it's some type of embezzlement case, usually if someone's accused of taking something from their employer, the employer starts to blame everything on them, right? And sometimes we can show in that type of case that all these claims of the supposed victim just aren't believable. So that's the factual approach to a case. And the factual approach is usually best used in combination with one of the other 2 approaches. So the best possible outcomes usually use either all 3, force, facts, and follow-up, or 2 of the 3. So let's talk about what I mean by follow-up. And by follow-up, it means mitigation. It means typically getting some type of evaluation that recommends some type of treatment and then following up and doing the treatment that's recommended. In a case that's involving a serious domestic violence case, it might be doing a domestic violence evaluation and following up with treatment, or signing up for DVMRT and following up with the classes. In some cases, it could be a mental health case, right? Maybe depression or something like that. caused the theft that was involved when someone took something. And so getting a mental health evaluation, following up with the treatment, is a way to try to show the prosecutor that we're taking care of the problem that led us to this situation. And perhaps because we're taking care of that problem, also perhaps based upon the fact issues that we developed on the other part of it, makes it easier for the prosecutor now to justify reducing that charge from a felony to a misdemeanor. Because let's face it, the prosecutors absolutely cannot take every felony charge to trial. There's simply not enough trial dates for how many people are charged with felonies. So how do prosecutors handle their calendar? A couple different ways. One, they can offer reductions or even dismissals sometimes to cases that they feel it is warranted based upon their caseload, right? If I have 50 cases and I can only take 10 to trial, I got to get rid of the other 40 somehow. And it might be by offering reductions. They also might get rid of the other 40 by being the mafia. Well, if you don't plead to this felony, I'm going to add 2 more. And you're not going to do 10 months, you're going to do 80. And so your attorney is going to know if the prosecutor has any realistic threats to add charges to make your case worse. And I'm all about transparency here. That's typically what I see in Snohomish County, right? They will typically charge low and threaten high as a way to clear out their calendar. My opinion, my experience. As far as what you can do then with the mitigation, you got those mitigation, that follow-up, you mentioned the facts, and maybe that's not working exactly, they're still not willing to do it, well then maybe it's time to use force. What do I mean by force? That doesn't mean we're bringing a weapon in, we're not punching out people. It means we're actually pushing the case towards trial. We're forcing the case towards trial. We're forcing them to do the work. We're forcing them to meet their burden of proof. Now, as you might guess from what I just said, this can be more risky because once you start forcing them to a trial, that's the time when they start using force back. Oh, well, we're going to add these charges. I guess we're adding these charges to make it worse for you. Or, hey, that original offer where we're going to let you plead to the low end is off the table. Now it's the high end. And we're going to add an aggravator too. We're going to throw 5 more years on you. So if you're going to use force, you have to make sure that your attorney believes it's not going to make the situation worse. Because the government usually has some pretty strong evidence that is likely to be believed by people that are on a jury, right? Jurors like to convict people. Remember what I just said. Jurors like to convict people. Humans like to scapegoat others. Humans like to feel safe. Humans like to believe the police. How many times do you watch a murder show or Dateline or something like that? How many times is there a not guilty? Any? 1% do you get to see that? They're not cherry picking. There's plenty of not guilties in the world, but there's far more times when a jury is going to ignore beyond a reasonable doubt. They don't understand that. And it's just really lip service. If people feel someone did it, it's very hard to find somebody that can stand up and is powerful enough to stand up to other jurors to say, I believe they did it, but the state hasn't met its burden. I mean, that's more law school and more fantasy than reality more often than not. So if you're going to go the force route, make sure that they can't make it worse. Personally, I like the follow-up treatment and the fact route, and I usually like to talk really loudly about the treatment side and really softly about the fact side because we're trying to get the person that is the prosecutor to give you an offer of a reduction. If you go strong at the facts, well, sometimes they go strong at the facts back and you dig them into their police report. And guess what? The police report doesn't say anything good for the suspect. That's not what we typically see, because if it said something good for the suspect would not be in this position to begin with. So it's not impossible, but think you have to do it all. You can't just, rest on conviction. Well, I didn't do anything, so I'm not going to do anything. Or the truth is going to set me free. Or the system's going to work. If you believe that, welcome to jail. You have to do it all. We got one life. We got one chance. Let's use all three ways to try to get that felony reduced to a misdemeanor. So I hope you found that useful. If so, please like and please subscribe. More people get to see it. More people get the help they need. More importantly, if you have a criminal matter in Washington State, feel free to reach out to our firm. We've been doing this for more than 20 years. We get on board, we'll listen to what happened, we'll identify a way forward, and we'll be there for you. Thank you.